Okay, good morning everyone and welcome to the preliminary Matter 4 hearing session for the Baber and Mid Suffolk Joint Local Plan Examination. My name is Malcolm Rivet and I'm one of the two inspectors appointed by the Secretary of State to examine the plan for soundness and legal compliance. Now, the purpose of this preliminary hearing session is that I have a number of questions to put to the Council on Matter 4, which might result in the need for some further work. Given the postponement of the hearing sessions earlier this month, I think it makes sense to add these questions now in order that if further work is necessary, it can be undertaken in time, hopefully to inform the full Matter 4 session due to take place in the autumn. Now, for the sake of completeness, we'll go through each Matter 4 question, but on a number of the questions, I have no further queries at this stage, although just to say more detailed discussion is likely to take place involving other participants at the autumn session on those. I'm intending to take the questions in order, apart from question 4.10, which we'll address immediately following question 4.6, but otherwise we'll do them in order. Just before I ask the council representatives to briefly introduce themselves, just to say that we're in various places across the country. I imagine it may be very hot or get very hot wherever you are, so feel free to take jackets off, ties off, whatever. The important thing is that you're comfortable and able to contribute and concentrate without feeling really uncomfortable because of the heat, so that's all fine. But if I could now turn to the council and ask you to introduce yourselves, please. If I go to Mr. Hobbs first.
Thank you, sir. My name is Robert Hobbs. I'm the Corporate Manager for Strategic Planning at Baber and Mid Suffolk District Councils.
Okay, and Mr. Deacon.
Yes, good morning. My name is Matt Deakin. I'm a Senior Planning Policy Officer at Baber and Mid Suffolk.
Okay, and Mr. Malloy.
Good morning. My name is Dan Malloy and I'm Acting Senior Planning Policy Officer at the councils.
Okay, and then Ms. Nichols.
Hi, I'm Kate Nichols. I'm the Associate Director of Planning at LUC. LUC carried out the most recent stages of the sustainability appraisal on behalf of the councils.
Okay, thank you. And Ms. Temple.
Good morning. I'm Sarah Temple. I'm a Senior Planner at LUC and I've been working with Kate on the sustainability appraisal.
Okay, and last, Mr. Bedford.
Thank you, sir. My name is Michael Bedford, Queen's Counsel. I'm instructed by the councils to provide legal support through the JLP examination process.
Okay, well, unless there's any sort of procedural queries beforehand, people are shaking their heads, that's fine. We'll start the main meat of the discussion. Question 4.1, has the settlement hierarchy set out in tables 2 and 3 been derived using a robust and objective process? I've read the council's statement on that. I've no further questions on that at this point. As I said just before, I expect there'll be some more detailed discussion on that at the full session in the autumn. But for the moment, I've got nothing more on question 1. So we'll move straight on to question 4.2, which is whether it's sufficiently clear how policy SPO3 part 1 would be applied to both development on sites allocated in the plan and applications for development not on sites allocated in the plan. Now, having read your statement, I understand you're saying that in relation to allocations in the plan, you're not intending that this policy would be applied as such. That's fine and makes sense, but I think the policy would probably need to say that to make that absolutely clear. Well, ideally, I would say in the policy itself, but if not that, certainly in the supporting text. We'll come on sort of later as to other modifications that may be necessary, but I think that does need to be made clear. So is that okay? Have you got any? You haven't got any problems with that? No, right? Okay, we could. As I say, we can talk. No. Okay. Then moving on to development on sites not allocated in the plan, if in effect windfall development. I'm struggling to understand how part 1 would be applied to a windfall development, because later on part 3 explains that within settlement boundaries, development in principle is it would be supported. Outside development boundaries, now we'll come on to the precise wording about that, but outside settlement boundaries, in principle, it's not going to be supported. So that is very clear. So I'm wondering how, in reality, in relation to a specific development, part 1 would be actually applied and when it would. So I'm taking, for example, say we had a windfall housing proposal for, say, 50 dwellings. Now, I'm presuming if that came forward within, say, a town or core village, within the settlement limits of that, development limits of that, then that would be, in principle, supported. Yes, the other policies of the plan would have to be applied, but yes, in principle, that would be supported. Is that right? Yeah. Now, if it went down to, say, a hinterland village, which is the next one down, they also have settlement boundaries, don't they? So would that apply as well, that the principle would apply, that in principle it's acceptable, so this housing proposal for, say, 50 dwellings would come forward and would be in principle acceptable there? That would be acceptable too?
I think the intent behind the policy is that, yes, it would enable that situation as well. Noting, however, that the spatial distribution, the settlement hierarchy would be followed in terms of an order of preference. But when you get to hinterland.
But can I just stop you there, because you say this order of preference, that's the bit that I'm thinking about. We've had an order of preference maybe in relation to allocated sites, and we'll get onto that later as to how allocated sites were determined. But this is a windfall housing development that's come forward for 50 houses within the settlement boundary of a hinterland village, so low down the. So would you just say, right, well, I mean, in effect, it seems to me that 1 and 3 could potentially conflict, because part 3 says subject within the settlement boundaries, that's in principle fine. So if it met all the other policies of the plan, that would get approved under that. But then you've said, but it would be not, you've sort of implied that it wouldn't be sequentially preferable, but that how would you refuse, or would you seek to refuse a windfall housing development for 50 houses in a hinterland village on the basis that hinterland villages are too small for such development?
No, that wouldn't be the intention. No, it would be a number of factors, many of which are specified in part 1 of the policy, which would need to be balanced and taken into account. So the settlement hierarchy on itself wouldn't be a reason for refusing something in a hinterland in preference of something in a core, for example.
Right. So what grounds would you? This is what I'm difficulty understanding. So there's a windfall housing development for 50 houses in a hinterland village. It meets all the other policies of the plan in terms of design, landscaping, living conditions, all that, environmental. It meets all those, and you're satisfied that under, I forget which policy it is, but under the policy requiring that development has its own infrastructure and services, or there is sufficient, it meets all those. Is there any factor in part 1 that you would then say, but we're not going to approve it because it's a hinterland village?
Would it be helpful, perhaps, just to distinguish by reference to the policies maps between as it were, your scenario, which is 50 at a hinterland village inside the settlement boundary, and obviously 50 at a hinterland village but outside the settlement boundary, because one of the factors obviously we haven't looked at yet, but the process of identifying the settlement boundaries is perhaps, and this may be a matter for Mr. Deakin to comment on, is how frequently or likely is it that there are actually sites inside the boundaries of hinterland villages which would have capacity for of the order of 50 dwellings or thereabouts, as to whether that's a commonplace occurrence because of the way that the settlement boundaries have been drawn, or that's a relatively rare occurrence because of the way the settlement boundaries.
Yeah, I would have thought it probably is, yes. Yeah, okay, so is and I was going to come on to that in relation to point 3, which is probably my next question, which is this issue about whether we're talking. So what I understand you're saying is, within, unlikely as that may be, that scenario, if I don't know, if there was some sort of factory or something that had got quite a big site and had closed down, then you'd have no problem with that in the settlement boundary of a hinterland village. But what your concern is, I think I'm understanding what the council's concern is, sites adjacent to the settlement boundary but outside it, right? That's where your concern is, right? Okay, but in terms of within the settlement boundary, you're saying if it's within the settlement boundary and it meets all of the things, then you're not going to take the settlement hierarchy into account. Is that?
So the purpose of our settlement boundaries is to define where the principle of development is accepted.
Yeah, right. Okay, so I'm clear on that. So, okay, well, let's move on then to question 4.3, which discusses the exceptional circumstances, because this comes to this point. This is the last sentence of part 3 of the policy. Now, I ask questions about, is this in accordance with national policy, thinking, well, I'm not convinced it is, because national policy does not say that development in the countryside is only allowed in exceptional circumstances. It's not a free-for-all by any means, but it doesn't say exceptional circumstances. In your statement, you've come back and said you'd be content to reword that, or suggested rewording that to something along the lines of, outside of defined boundaries in isolated locations, development will only be permitted in the circumstances specified in national planning policy. Yeah, and that, I think that's fine. I have no problem with that, so I'm okay with that. I suppose what, though, I would go on to say is two further thoughts on that. The first of which comes back to what we've just been talking about, is looking just at that sentence, the last sentence of point 3. Outside of the defined settlement boundaries, but in isolated locations. So that's a bit ambiguous, because we're not just saying anywhere outside the settlement boundaries, we're saying outside the settlement boundaries and in an isolated location. So there's lots of planning judgment there going to have to take place as to whether it's isolated or not, isn't it? But I'm thinking that's probably where you're envisaging that if it was a hinterland village and it was outside the settlement boundary, and it was a quite large site of say 100 houses, that would be one where you'd be thinking, well, this isn't the right thing to do. This isn't right to allow this as a general point of principle, because this is a fairly large housing development outside the settlement boundaries of a very low order settlement. Yeah, yeah. But if it was, say, a core village or the town, a town, does that make it any better if it's out? You've set the settlement boundaries for those. Does that make it any better if it's adjoining the settlement boundaries? It's still open countryside, isn't it? It's still using the value of the intrinsic value of the countryside for its own right. So assuming you've allocated, well, you say you allocate, the plan allocates more than enough housing to meet your requirement, 20% more than meeting your requirement. So why would you be granting permission for a housing site outside the settlement boundary of a town that's arguably not needed, taking up probably greenfield land? Why would you be doing that at any settlement? That's what I'm trying to is.
I think the way we've expressed the policy is that we've said the settlement boundaries identify what is required to meet the needs, including the buffer. So it sets out all of the land that's required to meet the identified needs, including the 20% buffer or approximate 20% buffer that we've allowed for. And therefore, it is on the applicant to demonstrate that if another site is therefore required, it is required on its own merits, not necessarily to meet the needs of the plan.
But then it wouldn't. On what basis would it be required? I mean, that's the purpose of housing within the urban areas, isn't it? You define the urban area, you say, well, generally, as long as it meets the policies of the plan, it doesn't matter how much housing goes in there. But outside the settlement boundaries, it's presumably what you would define as countryside. It's not necessarily going to be isolated, but it will be presumably what you call as countryside. So why would you be allowing housing in the countryside that isn't needed to meet your housing requirements? Why would you be doing that? On what basis would you allow it?
Well, there may well be a scheme that has a particular planning benefit to that particular locality, whether it be unlocking a particular piece of infrastructure or a regeneration opportunity, for example, which doesn't necessarily.
But that might happen with the hinterland village as well, mightn't it? There could be a site at a hinterland village that is not for 50 but is only for 10 houses, say, or whatever, and that might or it might even be for, say, it's for 50 and suddenly that's going to be for 50 but it's going to bring some amazing benefit to that hinterland village, some new development, something or other, then that would apply to a hinterland village as well, wouldn't it? It doesn't seem to me that it's relevant to the settlement hierarchy, if you see what I mean. I mean, I suppose what I'm saying is if part 1 of the policy was deleted altogether, right? And you had part 2 and part 3, we'll come on to part 4 in a minute. And part 3, the last sentence said, outside of the defined boundaries, development will only be permitted in the circumstances set out, specified in national policy, right? If it said, I'm thinking off the top of my head here, so but that would achieve all you wanted to achieve, wouldn't it? But would be much less ambiguous as to what all this stuff about what an isolated location is and where it isn't, and whether it's and then defining an isolated location and then trying to combine that with something about the settlement hierarchy in point 1. It's just an obscure. There's no certainty there, is there? If I'm a developer of a site within or on the edge of a settlement boundary, I've got no idea whether I'm likely to get planning permission because it's all so obscure. But if the policy, if it was point 2, point 3, with the last sentence of point 3 saying outside of defined boundaries, development will only be permitted in circumstances set out in national policy, that would,
well,
you can add, or where there is some specific benefit, justifying the development. You could even put something like that. Wouldn't that achieve everything you want to achieve, but be much clearer?
I think it's certainly something we perhaps want to reflect on, but I think one of the potential difficulties that has arisen out of the way that the courts have viewed that expression isolated homes in the countryside. I'm thinking in particular of the Braintree case, where, as you will no doubt recall, it has been argued unsuccessfully that isolated, in a sense, has two strands to it. One is simply a physical proximity to anything which might be called or classified as a settlement. And if something is close to, adjacent or abutting, then it's not isolated. And the other argument has been that isolated also captures things like relative sustainability and access to services and facilities and so on. And the court seem to have taken the view that when the MPPF uses the word isolated, it's only dealing with the former place that could be described as a settlement, whether it's a hamlet, whether it's a large village, whether it's a small village or whatever. And therefore, the type of issues which are captured in criterion 1 or part 1 of SPO3 are not themselves factors that would be capable of being reflected in that national policy test as the way that the courts have interpreted it. So that if sorry, I was going to say, if you were to remove one, you would then have potentially a situation that a development which was simply adjacent to somewhere that could be described as a settlement, which in a Baber and Mid-Suffolk context could be quite a small location, might have no immediate facilities and in one sense be regarded as isolated, but because it's physically, you've proposed a site physically adjacent to the hamlet, one wouldn't be able to point to national policy.
But that's why I said take out the reference to isolated locations development and just say outside of defined boundaries, right, development national policy. So you're taking out that in isolated locations because it's so yeah, it's not helpful really, is it?
Well, yes. I think that certainly would be a way forward. I think all we would want to ensure is that it couldn't then be said that we'd, as it were, gone beyond the extent of national policy because we hadn't got an equivalent of what I think is now paragraph 80 of the 2021 MPPF, but it was paragraph 79 of the 2019 version.
Right.
I think what we were trying to do, and obviously we certainly would accept, I think, your point that the present wording and the reference to exceptional circumstances is certainly capable of being misconstrued as to what that was trying to get at. Whereas what we were trying to get at was a reflection of the national policy in relation to isolated homes in rural areas. But having, as it were, done that, then potentially we've created additional problems. We obviously created confusion in terms of the intelligibility of the policy and how the different strands of it work together. And as I say, I think we would be very open to giving that further consideration as to the best way of dealing with this. But I would just be anxious that the editing process, as it were, we didn't lose the elements in criterion 1 or part 1, which are actually useful for dealing with what might be development adjacent to a smaller settlement.
But it comes back to my point that I put to Mr. Deacon. Why would you be allowing any development outside any settlement boundaries of any, unless there was a very good reason for it? You're not going to be, are you? That's the point. You seem to be wanting. You seem to have got into this situation of trying to distinguish between the high level settlements and the low level settlements, when actually you're saying, well, we would refuse it outside a main town, outside the settlement boundary, unless there was some very good reason why development should go ahead there. We'd refuse it anyway, as long as we were meeting our, our overall supply, our 5-year supply, and 20% over allocation. So it's not as if it's why would you be allowing it anyway? They're all going to have to demonstrate they've got some very good reason why to develop outside the settlement boundary. That's the point of settlement boundaries, isn't it? So why confuse the situation by bringing in the settlement hierarchy that I think sort of just confuses and just leads to this opaqueness? So I think we've probably taken this as well. Can I ask you, do you understand my point? I think, you see, what I think is, and it comes back to the very beginning point, which I think policy SB03, I think, was probably written thinking about how you were determining the site allocations type of thing, and that is obviously the settlement hierarchy is an important part of that, and then it sort of gets left in there in relation to what then becomes windfall, but it's only really going to be applied to windfall anyway. I think that's the point, is be thinking this policy is actually only applying to windfall, isn't it? So get that into your and then therefore what do we need to say in relation to windfall, and whether it's inside or outside a settlement boundary. But before we leave that, if I guess you to go away and look at it, then the other one I've got a bit of a problem with is 4. And this was question 4.4 and 4.5, those questions which we can take together, which is about this. Now, I wondered what the relevance of A, B, and C were to the settlement hierarchy, and in your statements you say, well, you think these are really important points, and although they're covered elsewhere in the plan, you think they're really important to be a strategic policy. I sort of think, okay, I can understand that to a degree, but it seems to me a very slightly odd collection of points from all other policies of the plan. So hedgerows seem to be of crucial importance in soft landscaping, but there's no mention about ensuring highway safety or all the other things that the plan picks up. And the fact that you pick out these sort of 3 things sort of makes me think that, well, they're obviously far more important than any of the other things, but I'm not entirely sure that that's what you mean, really, is it? I mean, why are those 3 things? Why those 3 things and not other things? Why not highway safety? Why not environmental quality, sustainability? Why not those things? Why these 3 things? So whilst I don't have a massive problem with them, I just think it undermines the other things. So people will come along and say, well, yes, our development, development might come along and say, oh, well, yes, our development isn't very good in terms of highway safety or access or parking or any of these things, but it's got great soft landscaping and we're retaining some hedgerows, and that's what you, the council, think is most important, therefore you should be allowing it. And if that went to appeal and I was the inspector in that appeal, I think, well, I can buy that argument because this is their strategic policy, this is what they say, so why are they mentioned? So I'm thinking, does part 4, I mean, you say in part 3, the principle of development is established within settlement boundaries, subject to the other policies in the plan. Well, what does part 4 add to that? It doesn't seem to add anything, does it? The other policies of the plan cover all those things. So why have them? Why have them there?
I think that the purpose behind them was basically through developing the plan. They were issues that had repeatedly come as repeated issues through planning committees, but it wasn't meant to be to the undermining of other issues that, as you say, equally can come forward at points in time as well and be equally important to determination of planning applications.
But you can see how it could be interpreted that way, because why mention trees and hedgerows but not other things? So
that wasn't the intention.
Right. I mean, but I think I'll leave it with you to look at this, but you understand my concerns. And I'm thinking that if SPO3 was basically part 2, part 3 with the last sentence amended, and I think it's that last sentence that needs the careful thought, to my mind, that achieves everything that needs to be achieved and everything that you want to achieve. But shall I don't want to force that on you to force you to say yes, but so I'll leave that with you. But can you think about that and think about making that clear and remembering that we're talking about here windfall development, because that's all it's going to apply to, isn't it?
Yes, I mean we're mindful of lots of comments that have been made on that part of the policy as well. So we'll certainly bear your comments in mind and seek to look at it with other comments that have been made as well and come up with a better solution.
Right. Okay. Well, I think that probably does. Question 445. You understand my concerns. If you can go away and think about that, we'll come back at the end as to sort of timescales for all this. But that's that one. Okay, let's move on then to question 4.6, and this relates to spatial distribution and policy SPO4. So the question is the proposed distribution of development set out in policy SPO4 based on robust and objective evidence, and is it justified and consistent with national policy? Does the distribution appropriately reflect the Ipswich strategic planning area wide growth objectives? So we had some initial questions on this, generally related to this matter, which you put a paper in, which is on the website. So I've read that. I've read the your statements on this. I think there's two sides of sort of your answer and the general issue which I need to understand. The first one is the figures, and I've got discrepancies in the figures that I can't get my head around, so we need to talk about that. And then secondly, hopefully that's a fairly straightforward thing to solve. And then secondly, I want to understand and get into how the distribution was derived. And I think, just to explain, I think there's obviously an overlap then with site selection, which is why I then want to bring in 4.10 after that. So that's the order we'll take things. But first of all, in terms of the discrepancy, I just want to understand. So I understand the point that the council has made repeatedly, which is a substantial proportion of the housing supply will come from permissions that already exist. And this is where there's the discrepancy in the figures, because in the essay and in your statements, you say that for new homes, I think this is, I'm just checking your statement. Yeah, this is 6.02 of your statement, page 4. You say that for Baber, there's approximately 3,500 homes left to be found, and for Mid Suffolk it's 4,400. But when I look at SPO4, the new homes is 5,575 for Baber and 8,000 for Mid Suffolk. So they're not the same. So am I right in thinking the difference of that is the permissions that have been granted since the 1st of April 2018? Is that?
That's correct. That's correct. Yes.
Right. Okay. So that's that difference. So this is always this. We often have this problem with plans. It's always this problem when you have these policies like this that set out these numbers, very exact numbers, and they're constantly wrong. So I think we need to have a think about how we deal with that, because I think that the plan is then just confusing, isn't it? Because it's just it's confusing. So I think we need to think about how we deal with that. But at least I understand what that is. So I've understood that. Right. That's Good. Moving on then to how the distribution was derived. I've read all that you've said. I've read all the evidence that there is in relation to this, and I end up thinking there's a lot about process that happened, but then there's sort of seemingly key decisions that happen almost as if it's happened in a black box, and the result comes out at the end. And my job is to test, or our job is to test, whether or not the distribution is justified, and whether or not the site selection was justified. And there's lots of emission site developers saying no, it's not justified because their site should be in for whatever. So I've got to consider all this as to whether the site selection process was justified. And although all the evidence is very good in setting out what the process was and was clear, I end up thinking, yeah, but there's some decision that's been made somewhere, and that's not very clear as to where that was. Can I, to sort of explain that a bit further, take you through my understanding of how, and we'll just talk about the spatial distribution at the moment, how that was derived. So at the preferred options stage, you had 4 spatial options in each district, didn't you? And I'm looking here at, I think this is the spatial housing approach topic paper. And on pages 4 and 5 of that, well, on page 4 it sets out BHD1, BHD2, etc. For each of the two districts, doesn't it? So it does that, and that's percentage figures, and I understand that, and that's clear. Then, as a result of that, you came up with that went out to consultation, and as a result of that, you came up with a preferred spatial option, which is detailed on the next page, page 5. Yeah, right. Okay, I understand that. I appreciate that the total figures then changed. That's a further complication, but that was the approach. The next thing, as I understand it, was the essay, and I'm turning here to the essay on page 46. You probably don't need to get it up or anything. I'm not going to ask a sort of detailed question about it, but the essay at this stage referred to the fact that these 4 preferred options, I think, had been looked at, and then it looked at 9 options detailed out there. So 9 different options. They're sort of done in a different way, and some of them overlap, and but with the previous 4, but it does 9, and it concludes paragraphs 531 to 34, basically that a focus on market towns, urban areas, the Ipswich Fringe and core villages would be the most sustainable approach. So it does that, yeah, right. I'll Mr. Deacon, I'll wait for you to catch up, Mr. Deacon, if you just get in the papers.
I am with you, sorry.
You're okay? You're okay. I don't want to, like, I know exactly what I'm going to be referring to, so I've got it all. So then the essay, it decided that, and then the essay then looked at Sheelar capacity, didn't it? So it looked at the Sheelar capacity and looked at, well, yeah, great idea to say that the development will be in the market towns, the urban areas, the Ipswich Fringe and the core villages, but if we haven't got enough deliverable sites in those areas, then that's a meaningless distribution. So we will look at Sheelar capacity, all very sensible. So it does that sort of page, it's chapter sort of 7 type of thing, and it does it in SPO4. I'm on page 235, 236, 237, and it then identifies for each district 2 further different preferred options, well, not preferred options, 2 further reasonable options, B and C, for each of the 2 for each district, right? And they're detailed there what they would be, and it details how they were formulated, where they came from, and how they were derived. And then suddenly, and this is the first time I see it, it sets out JLP policy SPO4, so what's actually in the policy, and compares it against that. And I think, oh right, but where did that come from? Where did that figure ever come from? I've got all this stuff on how all these other things were derived, and then suddenly the thing that is actually in the plan seems to come out of nowhere. It's different from the preferred options. It's different from these options that's being assessed as a reasonable alternative. So where did it come from at that stage?
In terms of the final figures part of SPO4?
Yeah, when I'm looking at page 237, it's got A, B, and C for each of the things. It's got B and C, which are these other options based on Sheelar capacity, and then A. Well, where did A come from? How was A derived?
Right.
A is what's in the plan, but where was it derived from?
A was the policy itself, and where those numbers had come from is basically a combination of the whole process that we've gone through in terms of a top-down exercise, working out the preferred spatial distribution, taking account of areas where there are matters of infrastructure constraint, areas where that fit within transport corridors, and then a bottom-up exercise. So that takes you to a point where you have a kind of, I suppose, a rounded percentage number. Right. And then how the other side of SPO4 is constructed is that a bottom-up process has come in, which looks at, so what actual sites have we got across the two district areas that are reasonable alternatives to actually take forward. And the council has gone through an exercise of identifying those specific sites, and then those numbers have then fed back into SPO4 to make them precise numbers rather than kind of broad numbers.
Okay, yeah. So then the essay, as it's required to do, sets out why it discounted these other two options, well, other four options, 2 options for each district. And that's set out at first, it's highlighted green, set out, I think, first at the bottom of page 241, and it's identical wording, absolutely, I think it's absolutely identical wording for each, why it's discounting each of the 4 options for the 2 options. And it says that the other options were discounted because the alternative spatial spatter is discounted as the proposed policy distribution is considered the most balanced and appropriate mix, accounting for the availability and deliverability of sites, the sensitivity and constraints of the area, and the infrastructure capacity and opportunities, which is what you've just said. Okay, but how can I assess whether those judgments that were made there were justifiable? Because where are they? Where is the evidence that sets out those? When did that happen, and where did it happen, and where is the written down evidence that I can look at and go, yeah, that's why that happened, and that's why that happened? I mean, it appears to me is it only what is in relation to site selection in relation to why individual sites have been selected and not selected? Is that where that evidence is? Or is it somewhere else? Is there somewhere that sets out this is how we've come up with this final our final SPO4 figures? Because
so yeah, the rationale has been a top-down, bottom-up process. Yeah. And forgive me if I'm repeating myself slightly, but the top-down process has involved taking the spatial distribution that was preferred, which of those 4 original options we touched on.
Can I just interrupt there, because you are repeating yourself and just telling me again what was done, but where is the right. There must have been some meeting, some discussion. They didn't just miraculous that event nowhere, did they? The preferred the figures in SPO4, which are different to all the other options that have been considered, which reflect obviously the sites that have been selected against many other reasonable alternatives. They have all been selected somewhere, and you're describing that they were selected, but where is the evidence that writes down, well, this is selected for this reason, and this isn't selected for that reason, and this is our top-down consideration, and this is our bottom. This is how we've come up with that. Is that written down anywhere, or is it only what is in site selection, really?
It is only what is within the SA process that we've just walked through those paragraphs and the bottom up side of it through the site selection process.
Yeah. So in relation to that, right? Okay. That's yeah. Okay. So what we're saying is that site selection it's been a top-down and bottom-up approach, but site selection is ultimately crucial. The site selection process is ultimately crucial in determining the overall spatial strategy.
It is, although at a high level, the decision was made to allocate a broad volume of dwellings to a certain category, and then the flip side of that analysis basically then looks at, okay, so if we're going to have, for argument's sake, 30% in a market town, what suitable sites have we got available that can actually deliver 30% in that area? And if that process ends up with a figure where you add up all of those dwellings and the figure becomes 33% rather than 30%, that's been informed by the sites that are actually picked.
Okay, but that yeah, and that's good planning, but and we'll move on to 410 because I think this will bring out some of this. That's all good planning, but I need to see to ensure that the spatial strategy is robust, and I have people telling me that it isn't. I need to understand how you reach those judgments, not how you reach those, but where those judgments are. I need to be able to see them so that I can understand, yeah, well, that's the reason why it's 33% and not 30% or 25% or not 19%, isn't it? Because that line at the bottom of page 241 of the SCA, of the SA, which just says, well, we considered this was the most appropriate mix, isn't really very helpful. You consider it's the most appropriate mix. Other people don't. I need to decide. So I need you to give me some evidence as to why it is the appropriate mix. Because at the moment, all I've got is, oh, you've just got to trust us. It's the most appropriate mix.
Well, so could I just apologise for interrupting?
No.
But it is, I think, worth making the point that, as you will recall, the 2019 MPPF, and it's the same in the 2021 MPPF, did make a deliberate change to the soundness test in relation to justified compared to the original 2012.
Yeah, I know.
Yeah,
an appropriate strategy over the most appropriate,
that is quite important, because something can be justified as an appropriate way of doing something, even if others could perfectly reasonably hold the view that there are other ways in which, as it were, the same result could have been achieved.
Absolutely, and I absolutely accept that point. There is more than one. There is more than one appropriate spatial option. I absolutely accept that point. But all I've got at the moment is that in terms of writing evidence, all I've got at the moment on why this is the an appropriate spatial strategy is because it's considered by the council to be preferable to the other ones. So how can I assess from that? I need to have some evidence to say these are the decisions that we made, so I could go, oh yeah, they are an appropriate strategy. They're not necessarily the only appropriate strategy or the most appropriate strategy, but they are an appropriate strategy. Whereas at the moment, I've got nothing to tell me that. All I've got is that line. The alternative spatial strategy is discounted as the proposed strategy is considered the most balanced. But there's no detail behind that.
Well, so
I think there might be in terms of site selection, but yeah.
I think we would certainly want to probably provide you with a note to explain that thinking process perhaps more coherently, and certainly in terms of the SA, particularly when you go through the SA and obviously its voluminous appendices, one of the points, in a sense, with all due respect to the detailed work that has been done, one of the things it points to is actually at an SA level there aren't, as it were, big differences between a number of these, as it were, different spatial strategies.
I'm not arguing. I'm not arguing that. I'm just saying I need some to determine that this is an appropriate strategy when I've got people telling me that it isn't. And even whether I've got them or not, it's a key part of the plan. I need to have some information to be able to say, write in a report, this is an appropriate strategy because.
Yeah. Well, we yes, okay.
All I've got is that 3-line sentence for the whole thing saying, well, it's the most appropriate strategy because the council decided that it was considered the most balanced and appropriate mix. That's all I've got. So let's move on to matter 4.10 because I think that might bring out some of the things and possibly my thoughts on some of the ways forward. But I just want to make that point clear that I need more than 3 lines of a sentence. We'll move on to. So you've said that the site selection process was a key part of the spatial distribution. That's fine. So that brings us to question 4.10 and the site selection process. I've read, the council's statement on this and the previous additional information and all the other evidence that there is, and I thought it would be useful to work through an example of a specific settlement just so I can understand what process took place. I've picked Bentley, and I previously let you know by the programme officer that I would do this. My colleague and I, we've got no specific thoughts on Bentley at the moment, so it's nothing to do with that settlement at all. It was just that's a very it's sort of beginning one on the sheet of all the settlements, and it seems to highlight a number of the issues that I wanted to explore. So that's the only reason for talking about Bentley. But so just as I understand the process, so there was a call for sites, and you would have looked at your own knowledge of sites. And as I understand it, 4 sites emerged for Bentley. That's correct? Yeah.
It is, yes.
3 of them are fully appraised through the Sheila, and I've got pages 61 to 63 that looks at land south of Station Road, land east of Bergholt Road, and land west of Church Lane. Looks at all those, and that finds that in principle they're all in effect reasonable options. They're all deliverable, available, and suitable in principle, right? Okay, and they're for 20 dwellings, and 60 dwellings, right? And then we come to Appendix E, I think it is, yeah, of the Sheila, which on page 425 has reference to land east of Capel Road, which is the Capel Road. Is it Capel or Capel?
Capel.
Capel. Land east of Capel Road, which is this 4th site, and that just says that this site has been discounted because of poor connectivity to the existing settlement. Now, is that the only? That's the only sort of appraisal of that, is that there isn't a. I mean, I would say a full appraisal, each only a sort of a page long, but there isn't a page-long appraisal for that site. It was just discounted on the basis that it was deemed too far from the existing settlement. Is that and at that point that was then
that was the defining reason, yes.
Right. So no other appraisal had been done of it. You hadn't compared it against anything. You hadn't done the other assessment that goes in terms of suitability. You haven't looked at highways, landscape, heritage, minerals, utility. It was just, look at this, it's too far from the settlement, we'll not consider it any further. Is that right?
No, it had the site had been regarded against all factors, so that there's a red, amber, green system set out in appendix. I think it's appendix A of the essay. So the Sheila, sorry. and that methodology had been applied to all of the sites that we have. The reason why it was considered not suitable was the reason published in Appendix E. So notwithstanding assessment against all of those other factors, the defining factor was the reason that's published in Appendix E for that site.
So is there in effect a table for this land east of Capel Road? Is there in effect a table that details that consideration?
For each of the Sheila sites, there is a table that goes through those RAG ratings. Yes,
and that's in the Sheila in.
It's not published for those sites. So the reason for discounting them is published, and the summary of the reasons for the sites considered to be suitable is published in the Sheila.
Right. Okay. I'm thinking, would it make sense for that to be published?
We can look at making that available. Yes, it's unfortunately not available as a report, but we can look at ways to make it a report.
Yeah, you could sort of revise the Sheila to include it, or as an addendum. Right. Okay. Because I mean, I don't want to get into talking about whether or not it is, has got poor connectivity to the existing settlement. I don't really want to get into that because it's not really the appropriate time. But it seems to me that I'm not disputing at all that judgment. Others may wish to down the line, but I'm not disputing that judgment at all. But just when I looked at them on the map, I think the council you provided a map of them, or blown up map of them. When I look at them on the map, the land east of Capel Road doesn't seem to be like a million miles further out of the settlement than the one on the opposite side of the main road. You know, it's not as if this is out of all bounds. It's not as if it's 10 miles away and these are all, so it seems to me a sort of planning judgment has been applied there. That's absolutely fine to apply those planning judgments, but I think if it's a planning judgment that has involved consideration of some other factors, then we need to see that full assessment. So if you could provide that for all those sites in E, that would be very helpful. Okay.
Yeah, I don't know whether it would be informed by it. The reason for discounting the site is the reason specified in Appendix E. However, it is part of a wider assessment of all the other factors. But the determinative factor for discounting that site is that specific reason. It wouldn't be relevant to all those other factors that may score green on lots of other things.
Yeah.
If that was the reason, then that is solely the reason for discounting those sites.
Yeah, I suppose what I'm trying to say is had the list of Appendix E, is it Appendix E? I'm getting my appendix mixed up. Had the Appendix E sites said, something like this site is not available, this site is not available, that would be, you say, well, what's the point of doing all this other assessment if the site's not available? The site's not available. Why do that assessment? But this, I think, is more of a planning judgment, isn't it? The reasons, many of the reasons here are more of a planning judgment. So I think it's important that we see the full thing was considered. Okay, well, that's fine. Right, so the Sheilas decided that 3 of the sites are in principle suitable, 1 isn't. Right, that's okay. And when I say that's okay, just for anybody else listening, I'm not saying I necessarily agree with that, but just I understand the approach that's been taken. So then we come to the essay, don't we? And the essay, Appendix E, appraises each of these 3 sites. That's right, I haven't got page numbers, I don't think, but it's Appendix E, and it's by settlement. We've got Bentley Parish, we've got the 3 sites, and they're appraised under full essay. Right, okay. And basically, having read what it says, the conclusion and the detail on this, it's like, 2 pages of of colours and pluses and minuses and all that business, and then a page of text sort of explaining what the major positives, the major negatives are. And that basically says that all the sites perform similarly, but the west of Church Lane performs better in relation to primary school proximity and transport links buses. Right, so that's clear. Some people may disagree with that, but it's clear as to the judgments. And then Appendix G, if I'm getting confused right, then it sets out, as the essay needs to do, why the sites were selected, and G1, I think it's the first page of Appendix J, hence why I picked Bentley, because it's on the first page. That says it selects the land west of Church Lane because it's located close to the primary school, and the other two sites are discounted for sort of the opposite reason, that they're not located so close to the primary school. So that's, I understand that, right? And again, I'm not saying whether or not I agree with those judgments, but and others may not, but it's clear what those judgments are. So what's in effect happened, as I understand it, is the essay has appraised these three sites against each other, hasn't it? And chosen one, saying they all perform fairly similarly, but one slightly better for this reason, so we're choosing that site, right? But they've appraised them only against those other two sites in Bentley. It hasn't appraised them against sites in any other hinterland village or any other settlement in the district. It's only appraised them against those. So by default, therefore, there seems to have been a decision made that a site needed to be allocated in Bentley. If there was a suitable site to be if there was a suitable site in Bentley, then it should be allocated. Yeah, that decision must have been made somewhere because you were praising just against those other sites. So where was the decision that there needs to be a site in Bentley? Was the decision taken that there should be a site in all hinterland villages? If there's a hinterland village that has a site that is suitable and achievable and deliverable, then it gets allocated it. Was that decision taken?
No, it's not quite as simple as there is a site, therefore we are allocating there. It is having broadly worked out what the categories of the settlement hierarchy are, in terms of saying, okay, we're going to have a certain volume of dwellings in hinterland villages. We then look at the capacity for meeting that number of dwellings, and then that bottom-up process takes place. So we look at all of the villages in that category that have Shelar sites available in them, and by choosing the sites, there's a process of actually deciding on the volume of dwellings that would apply in that community. Right.
So and conveniently. I don't mean that sarcastically, because it is convenient. When I go back to the four options that the essay had looked at following the Shelar, the B and Cs, all the options had got for both districts 9% in hinterland villages. So that was the figure you were looking for. So you went around the hinterland villages thinking we need to find 9%, right?
Yeah, more or less, yes. I mean, that it wasn't kind of a mechanical target to say, right, yeah, that's it. I mean, sometimes we've gone more than the broad determinant was, there's a figure of, I mean, for argument's sake, approximately 10% needs to be found in hinterland villages. Now, through picking the sites and looking at all of the settlements involved, the figure that's actually come out with is 9%. That's the refinement from a broad number to a specific number.
Although it was it was a specific 9%. Even in the Sheila A and B options, it was 9% at that stage, wasn't it? But that's a bit beside the point. So, I mean, I suppose my question on this, and this is a question that many people, or an argument that many people are putting to us, which is there's too much in my settlement, and some developers are saying there's not enough in my settlement, and I'm thinking, well, why is there in Bentley, again, just for example, I could pick any, but just for example, why is there this one site of 20 when all three were deemed to be basically okay? So why wasn't there all three of them? Why wasn't there two of them? Why wasn't there none of them? And why wasn't there more in some other settlement? Or why, why wasn't there none of them in Bentley and some more in some other settlements? Because I think not every hinterland village does have an allocation, does it? Is that, I don't know.
No, I don't believe that would be the case, no.
Yeah, so there are some hinterland villages that don't have an allocation. So why did Bentley get 1 of 20 and not 3 or 2 or none? Why is that? And that's the bit that I'm thinking, well, that's what I don't know. And that comes back to, doesn't it? The alternative spatial pattern is discounted as the proposed policy distribution is considered the most balanced and appropriate mix. You consider it was the most balanced and appropriate mix because you decided that one site in Bentley, there were hundreds of these decisions, but you decided one site out of 3, all of which were in principle suitable, was appropriate. The other 2 weren't. But why? Yeah. And I'm not saying that you didn't have good reasons for reaching that conclusion, but I don't know what they are. And where is that? Is that written down anywhere?
So the decision making for Bentley would have been based around infrastructure matters with regard, school capacity, water, treatment works, highways capacity. It would have been having regard to sort of historic patterns of growth in the area, and also the context in which other allocations are being made. So not too far from Bentley itself, there's a number of core villages that are taking larger numbers, lot larger numbers than 20 dwellings, that are very accessible to Bentley. So that is part of the context in which that number is identified.
So that's all good stuff. That's planning, isn't it? That's good planning going on. Again, for anybody who's listening who disagrees with it, I'm not saying I necessarily agree with it, but that is the sort of factors that a council should be taking into account. But is that written down anywhere? Can anybody look at it and go, I understand. Now I understand why. Well, I might not agree with it, but I understand the specific considerations that led to one site of 20 being allocated in Bentley, not all 3 of them, not 2 of them, and not none of them, 1 of them of 20. I can understand why. When the reason given that this site was selected because it was the closest to the primary school is fine, but that was only why that site was selected, wasn't it, opposed to the other 2? But why weren't all 3 selected when they were all deemed to be very similar? Do you see my
Yes.
Yeah.
So all 3 wouldn't be selected because that would have been deemed to be too much for Bentley, given its status in the hierarchy and given the context of allocations in the neighbouring areas.
Yeah, but is that written down anywhere?
No, I guess it's implied, but not very well articulated.
Okay, right.
So could I just I didn't want to interrupt at an earlier stage, and obviously there's a flow and there's a dialogue, and so this is slightly taking you back to a stage, and it's probably not that important to your reasoning process, and I don't think it detracts from what you've just been putting to Mr. Deakin. But there was a point I just thought it would be helpful perhaps to bring Ms. Nichols in on, whereas as part of your exploration of the work of the SA, I may have misunderstood the way you were putting it. I thought that you had suggested to Mr. Deakin that part of the process in the work in Appendix E of the SA, which was then dealing with the 3 sites that we see listed for Bentley, and as you say, there isn't a page that I can take you to give you a reference to that. But I thought that you had suggested to Mr. Deakin that the scores, i.e. the coloured, whether it's green, orange, burgundy, etc., that those were achieved by comparing those sites against the other sites in the settlement.
No. I recognise that they were done on an individual basis, but it's the conclusion at the end that one of them is selected against each other, isn't it?
Well, that's where I think it would probably just be helpful to bring Ms. Nichols in, because the essay itself doesn't do the selection. But is it perhaps just helpful to hear from Ms. Nichols as to what the work was, just so that, I say, if I've misunderstood that, I apologise, but just so that there's no confusion. So perhaps if Ms. Nichols comes in, and then Mr. Deakin can obviously add further comment as appropriate.
Okay, that's fine.
Thank you. I was going to make the same point, really. Just in terms of the methodology that the essay used, all of the sites, all of the options across the whole of the plan area were appraised initially on a policy off basis, so purely on the basis of the boundary on a map against the same criteria. And they weren't appraised against each other as such. The way the appendices are set out is really a presentational issue, because I'm sure you can appreciate, and you will have seen a lot of essay reports that appraise hundreds of sites. And if you kind of dump all the findings into, huge summary tables, they can be quite difficult to disseminate. So we tend to find it quite a helpful way of dividing up and presenting the site options, because it helps with those separate decisions that are being made by the council about, between different settlements. So it's purely that the sites in the appendix are presented by settlement and summarised in that way. And then in the main report, all of the site options are presented, the findings are presented together in one overall summary table, and they're looked at much more in the round. But there's no comparative, like the scores are derived from the criteria that are set out and applied consistently. They're not scored in comparison to one another. It's purely how the findings have been reviewed and summarised.
Yeah, no, I appreciate that the scores were entirely, each site was compared on its own merits type of thing, not against anything else. I understand that, but it's the written conclusion for each then sort of compares them against each other in that site, in that settlement, doesn't it?
Yeah.
There is an implicit, if not explicit, that they've compared against each other in this settlement, not that actually. And I don't want to get into the details. Not that the site in Bentley that's been discounted because it's not close to the primary school may actually be closer to a primary school than a site that has been selected in some other settlement that's been selected, because that's that's got some other great factor, if you know what I mean. So they have been compared to some degree within each settlement at that final stage, but I accept that initially they haven't. And
I think it's worth noting as well, as you know, the essay isn't the only factor that feeds into the decision making. The essay report wasn't in any way attempting to determine which sites should be selected or rejected by the councils. That's a separate process, taking account of the essay and other factors.
Yeah, so that's fine, and that's what I would say. And it's getting to the point that I've got to with Mr. Deakin, really, which is, well, we had all this information, then we decided which sites to select based on the factors that he recalled. And they're all sensible, appropriate factors. But when I then say, well, where's that written down? Well, it isn't really. And that's the bit I'm saying, well, that's the bit I need to see sort of written down. Is it perhaps on this, coming on to a way I see as a possible way forward, which I think might be helpful, because I don't, well, a few points. We haven't had the session on essay yet, because that was postponed, and I think our intention would be that we would actually combine the essay session with Matter 4's full session, because I think the two things are so interlinked. So everything I say is without prejudice to that session, obviously, because I don't want to say, this is what's needed to the essay, or this is what's needed, and this is the final thing that's needed, and that'll make everything fine, because I obviously have to hear what others have to say about all this and about the essay. But what I think would be helpful is if, in effect, the work that Mr. Deacon said had went on as to how to decide how many sites in each settlement to decide, if that could be explained. And I'm wondering whether a way of doing that is basically to take each settlement in the plan down to hinterland village. So that's town core down to hinterland village, which I'm not, do we have a list? We don't have necessarily a list of them all, do we? Because I'm looking at table 4 in the plan here, but that's only the ones that are in a neighbourhood plan area. That's probably most of them, but it's not absolutely all of them, is it? Is that right?
Tables 2 and 3.
Oh, right.
Tables 2 and 3.
Sorry, I was on mute. Yes, the settlement hierarchy tables that go.
Oh yeah, no, yeah, oh, right, yeah, no, yes, yeah, you're right,
Yeah.
right, you're right, yeah. I've forgotten about that. Yeah, so that lists them all. In terms of hamlets, can you remind me, are there any allocations in hamlets?
There are a handful.
A handful, small number. Okay, it doesn't matter. It's a handful. I mean, what would be useful for me is basically if you could go through each of the settlements and say, you know, taking Belstead. Well, Belstead has been allocated this site briefly because, and we've got the reason why. And I think that the reason needs to be because it's in the Ipswich fringe. It's a high thing in the settlement hierarchy. And then say it hasn't got more, the settlement hasn't got more because, well, maybe there weren't any more sites to allocate, I don't know, or the only other site had some major problem or whatever. And it hasn't got less because, well, it's a high settlement. It's a high order settlement. So why, the aim is to give it more and to go down for each of the settlements down to the hinterland villages. And on the hamlet villages, I'm not asking you because it's going to be the same answer to many of them, which is, well, it hasn't got an allocation because it's a small village. It's very low order. It's not a particularly sustainable location to have housing, probably. And again, there may be people, I say that just as a general point, there may be in specific instances, but for the sites that do have an allocation, if you could perhaps just say why that hamlet village has been chosen for an allocation, because this comes back to my, hamlet villages very low in the hierarchy. One wouldn't expect it to have an allocation. If it had got an allocation, why has that settlement got an allocation? Why has the hamlet village got an allocation as opposed to Bentley not having more than 2, if not having more than 1? Do you see that?
Follow,
is that something that's feasible to do? It's probably quite a lot of work, I imagine, but that, to me, is only the work that you have already undertaken, isn't it? You have undertaken that work. It just needs to be written down in a format that people can see and I can see. So I could say that is why it's come up with this.
That would make sense.
And is that feasible to do that?
Yeah, it is feasible.
Yeah. The other thing I think it would be useful to have, which is where you say you've got the stuff, which is for the Sheila, is to provide the tables or whatever it is, the other evidence on the whichever appendix, the discounted sites, the sites that was discounted, as to why they were discounted. That would be useful. So we've got that information. Now,
so on that. The reason why they were discounted is in the Sheila, but as I understand it, what you wanted was the RAG process that had gone through the Sheila sites, which Mr. Deacon explained they had gone through that process, but we haven't presented the results of that. Yes, just be clear about that. Yeah, thank you, sir.
Yeah. Okay. That basically. Oh, well, I was going to say it doesn't bring us to the end because we've got to then go back and deal with the other questions. But it is 10 to 11. We've been having a hard go here. Mr. Deacon probably in particular needs a bit of a break and a cup of tea, as I do. Should we? I think we should break now. Does that make sense? If we break for, say, half an hour, is that all right? And return at 20 past 11. And at 20 past 11, I think probably what we'll do at 20 past 11 is go on to 4.7, 4.8 and 4.9, and then have a wrap up as to where we are, what work needs doing, what you can do, and timescales for doing that. Does that make sense? If
Yep.
The only other thing to say is if at the end of having done matters 4.7, 4.8 and 4.9 and a bit of a wrap up, you want time to go away and just have a chat amongst yourselves about how long this work's going to take, that type of thing, that's fine, and we can come back this afternoon and have that discussion if that suits. But I'll leave you to decide that. So I'm not going to put you on the spot and say no, we must do it now. We've got I doubt 4.7, 4.8 and 4.9 will take too long. So we can certainly break off and then come back this afternoon after you've had a chat if that suits you. But okay, let's break for now, and we'll return. If you can remind you just to put your cameras and microphones off, and we'll return at 20 past 11. Okay, thank you. Right, okay, thank you. Welcome back. Just before we move to question 4.7, there was just one further point that I forgot to mention earlier. We talked about an explanation for each of the settlements as to why the amount was the allocations were the allocations and it wasn't higher and it wasn't lower. What would also be useful as well as that is then for each of the settlement hierarchies overall, if you could do the same. So it's almost like I mean, it's not a summation of what the thing is, but that gives the overall reason as to why. I think that information probably is sort of there somewhere, if you know what I mean already, but it would just bring it all together, if you see what I mean. If the same sort of, it's, Ipswich fringe in Baber is this figure, it's not higher because, it's not lower because, that type of thing. But I mean, it's not repeating everything that's gone on in individual settlements, but just a sort of overarching summary. So if that could be done, that would be helpful. Moving then to question 4.7. This is sort of a carry on really from what we were discussing initially, which is, well, how does SPO3 play out for development? Well, for allocations, it's not going to be applied, but we've got the issue for windfalls, and we've talked about that. And then I think it's the same here, really, isn't it? In the sense that I mean, although this policy does strictly apply to allocations, it's how the allocations do, but it's not, an allocation isn't going to be ever considered against this policy as such, is it? Because it's already in the plan. So it was how it would apply to windfalls. And I think I have the same concerns really, in effect, as I had before, which is, and you've said in your statement that these aren't meant to be ceiling figures. So in a way, if they're not ceilings, what are they? Type of thing. Are they really helpful as policy? I think when you're going away and thinking about SPO3 and all that we talked about there, I think you need to think about SPO4 as well. I'm not talking about the actual, the percentage figures here. I'm not talking about whether it should be 20% or 30%. I'm talking about what the policy is actually saying. I just air this as I sort of wonder whether actually really this is supporting text, all this. It's very important supporting text, but it's not actually, a policy should be making it clear to the decision maker and to the developer as to how an application will be determined, and it isn't really helping that, is it? So, but have a think about that.
So can I just? I mean, we will certainly will think about that, but we had sort of taken it that what I think was paragraph. It's paragraph 20 in the same. It's the same paragraph 20 in both editions of the MPPF, when it talked about strategic policies should, and then it says set out an overall strategy for the pattern, scale, design, quality of places, and make sufficient provision for housing, etc., etc. That we absolutely take your point, and there's clear force in it that a policy which is merely descriptive of what the plan has done by way of its allocations is not actually a development management policy at all in that sense. And we absolutely take that point. But I think what we were just anxious about is that if you were to convert all of this into, as it were, supporting text, it's not supporting text to a policy, it's supporting text to the plan as a whole. And it's really just not wanting to, in a sense, fall between two stools of somebody then saying, well, your plan doesn't have strategic policies which do what paragraph 20 says it's doing. That's, I think, the only concern.
Yeah, that's a fair point, actually. That is a fair point about, what MPPF says. So I think that, yeah. Have a think about it, and I think we can have further liaison over it in writing, and then we'll see what you sort of come up with, and then that's going to inevitably be subject to further discussion at the Matter 4 session anyway. So yeah, but have a think about it. But I do accept that. I do accept that point. I think my nervousness comes, I think, in terms of once you start putting, well, for two reasons. Once you start putting these very precise figures in, one, they're always out of date. You know, they're out of date as soon as you put them in, but yet they're these very precise figures. And also, aside from the fact that they go out of date, it makes it look very much like this sort of very much development management thing that, well, you're only allowed 2,046 dwellings in here, and you can't have more, and you can't have, like, you know, so that's it. But I do accept the point that about what the MPPF says. So maybe a policy that sets it out much more in broad terms. This is what the thing is, but it makes it clear that it isn't to be applied on a windfall basis or whatever. That is what the windfall policies are.
Yeah.
Just one other thing, we'll probably come back to it a bit later, but just further thing, I've also I was talking to my colleague inspector in the break. LPO1, I think, which is windfall developments in hamlets and dwelling clusters. I think when you're thinking about SPO3 and SPO4, bear in mind LPO1 as well, because I think that obviously they all need to work together, but equally and without any, you know, conflict for certain, and ideally without any sort of repetition. But certainly they all need to, you know, work without ambiguity and conflict between them. Okay, so that's just well, that's I mean, I think 4.7 probably deals with we've dealt with that, but you'll go away and look at that. We then come on to 4.8, and this sort of quite complicated position with neighbourhood plans and what's being required of them and what isn't. My first sort of overarching question, which was, are the total homes required figures for neighbourhood plan areas as some of the outstanding permissions and the allocated sites? And you've confirmed that they are, and we sort of went through that before. So I understand the figures now, and I understand how the figures have changed in the essay and else your topic paper, so your hearing statement. So I understand that, albeit it just points to the fact of the difficulty of putting these precise figures in, that they're always changing. And 4.8a is, are all the outstanding permissions from the 1st to the 4th 18 identified as housing allocations in the plan, or do they need to be otherwise accounted for? So they're all allocations in the plan. That's right, isn't it? So anything that was a permission before the 1st of April 2018 is in outstanding planning permissions. New homes, I'm looking at the figures in SPO4, sets out the figures for each settlement category. All of those are either allocations in the plan or outstanding. Well, they are all out. Oh no, so there's some outstanding permissions which are for small sites which aren't allocations in the plan. That's right, isn't it? Is that right?
If there is a difference between the identified OPPs column, the middle column of table 4, and the right-hand column, the total homes required, if there is a difference between those two numbers, the difference is made up of allocations from the plan.
Oh, sorry, no, I was looking back over at SPO4, outstanding permissions and new homes. So outstanding permissions is anything that was permitted before the 1st of the 4th 18. Yeah.
Yes, it is. Sorry, yep.
And then the new homes is made up of, well, obviously apart from the windfall, which is there at the bottom, but the new homes for Ipswich Fringe, for example, is made up predominantly of allocations in the plan. But there are, am I right in thinking there are some small sites which are windfall sites that have been approved since the 1st of the 4th 18 that you haven't made allocations, or have you made everything that's been granted permission? Oh no, some of them will be counted as windfalls in earlier years. That's
yeah. So off the majors, the majors have been counted in that number. There'll be lots of windfall minors that haven't been counted, so they would appear as windfall.
Right. So if I total up in the Ipswich, well, that's complicated because, well, go with core villages. They're a bit more straightforward, although they all overlap, don't they? But, well, anyway, if I go with hinterland villages, 284. If I go with those, those the allocations in hinterland villages will add up to 284 in Baber. Yeah. If there's been any other windfalls in hinterland villages, they would be counted under your 500 windfall.
They would, yes.
Right, okay, I understand that. Right, that's helpful. So I understand that. Right. Okay. So question B was then, is it sufficiently clear as to how and when the requirement to identify the indicated total number of homes required in each neighbourhood plan will operate in practice? So SPO4 itself says neighbourhood plan areas will be required to deliver the total number of homes required. They can deliver more if they want to, and that's suitable, but they will be required to deliver that figure, and that's the right-hand figure in table 4, isn't it? They are required to provide that, and that fits back to NPPF, which says you should make clear what the neighbourhood plan area should provide for.
Yes.
Now, for some authorities, it's not authorities, for some neighbourhood plan areas, you know, Assington, for example, well, that's already got outstanding permissions for all of its 38, so it presumably doesn't have any allocations in the plan, and that's that. Right. For others, such as Bentley, outstanding permissions for 32, they've got requirement 52, and bingo, there's that 20 site for 20 that we were talking about before. So that, yes, I understand that. But what you're saying is that, and this is not in the policy, but it's in the supporting text, that if outstanding permissions granted as of 1st of April 2018, so that's the first column, expire, right, then corresponding number of dwellings will have to be allocated. Yeah, it'll have to be planned for. So they'll have to either do that through, well, I suppose this is it, how will they do it? So, and I'm also thinking that given that most permissions have an implementation period of 3 years, we presumably know already which of these have expired, don't we? Is that?
I think that's a fair assessment. I haven't got a list in front of me, but
no, I was going to answer, but we must do. We must. Somebody must know of those that have expired.
So I think our if you take it to its extreme case, our monitoring as of the end of this year just gone would sweep that up, and I don't think we've fully finished that monitoring process yet. But right. But yes, by and large, that should be the case. Right. I think one of the challenges for us at the moment is that in terms of dealing with expiries, because the council hasn't been able to do much on-site checks due to the coronavirus restrictions, there are some uncertainties about some sites, but we can do a bit more digging in terms of seeing what status they're at.
Yeah, it's not just it's not just a matter of whether it's 3 years since it was approved, is it? And there's not any house built. No, I appreciate that. It's a bit more complicated than that. But right, okay. But that would, I think, is useful because that makes the thing clear. It would potentially make the thing clearer, wouldn't it? That we would know what we were actually asking people to do. Now then, at the moment, just so again, so I'm clear, I think you said this before, but just so I'm clear, the difference between total homes required and identified outstanding permissions is solely allocations, isn't it? So
it is,
yeah. So allocations of this plan. So basically, what 911 is saying to accounts to a neighbourhood plan area is oh, well, just there then, this is a further complication. So if there's been a permission, in effect a windfall in one of these neighbourhood plan areas, which surely there must have been, since the 1st of April 2018, is that catered for in here? No, that's catered for in your 500 in the other figure, is it? other table.
It would be, yes, in terms of the numbers presented in the plan, it would be. But of course, a neighbourhood plan that's in production would be able to refer to that site in terms of them evidencing how they've met their need. So if they have a number that's been assigned to them from the plan, that right-hand column, whatever that number may be, an emerging neighbourhood plan, as long as they can demonstrate how that number has been met, whether it be for a windfall site or through sites that are already identified in this plan, the objective would be just to demonstrate that that number could be met.
Right. Okay. So if, for example, Little Cornard, it's got outstanding permission for 3, total homes required 3. If, and we've no idea, but if, for example, that existing permission for 3 is expired and it's definitively expired, but actually the council has granted windfall, because of course it's the district councils that are granting these permissions, not the neighbourhood parish, isn't it? But anyway, if you have granted 3 or 4 windfall houses in that area, within the last 4 years, then they are included, right?
Yes.
Then that they've met their
need. Yeah,
they've met their need. Right. Okay. So what the questions that I were asking was sort of about the fairness and equality of the approach of this. That what happens, you say if they expire from before the 1st of the 4th 18, they have to be sorted, and that's like this is the rule. You've got to sort that out for yourself, and you've got to identify your neighbourhood plan area. You've got to come up with a plan that includes an allocation for that, or there'll be some windfalls that we district councils have approved in your neighbourhood plan areas. We should know shortly which of those have expired anyway, won't we? So if they've expired, assuming we're happy, and we've come on to talk about that, assuming we're happy that the total homes required figure is appropriate, assuming we're happy, then this could be made more simple by just saying that is your figure, isn't it? That is your figure, and taking out, you've got to provide that. You've got allocations, you've got windfalls. If you need to meet it, if you need to hire, then you're going to have to identify some sites to be allocated to your neighbourhood plan.
I think it could be simplified once we had that definitive list. Yes.
Yeah.
I think it's just worth saying when we talk about a definitive list that in a sense, no list is ever definitive, because as you know, sir, it's always changing. If we obviously were to update anything to the position for the purposes of the examination, it would have changed again by the time the plan comes to be adopted. So there is a question as to in a sense, the usefulness of a different snapshot to bring it up to date to sometime in 2021. Well,
hence, this is the point if we are able almost to do away with the first column and just go, this is the requirement, it's much more straightforward, isn't it?
Yes, I think we could certainly see the sense of doing that. I think what we possibly just be a little bit concerned about is, and obviously we'll have our session at the end of this overall session, but in terms of further work for the council to do to inform you in the examination, going through an exercise of working out which permissions have expired from.
I see what you mean.
That particularly when, and although, as it were, as a rule of thumb, a permission will have 3 years, as you correctly identified, those which will be outline permissions and will be 2 years from final approval of reserve matters and so on. It may be a slightly more cumbersome exercise.
Yeah. No, I take the point. What's the point if we move to just to being a total homes required? What's the point of doing that exercise? Yeah. No, I agree. Yeah. No, but right. I think. And then my other question is related. Well, that's all fine because this policy, well, it's not even the policy, it's the supporting text, sort of says if any of your outstanding permissions have expired, which we know They will have done if they haven't been commenced. They will have expired. Probably they will have expired. Then you've got to identify more your site, more in your neighbourhood plan, unless you've got some windfalls. But if that only is in relation to allocation of sites, or if the allocated site that you've allocated in Oldham, for example, you've allocated site, if that just never comes forward, then they don't have to do anything about that, do they? If you see what I mean.
No, the neighbourhood plan wouldn't as such, but the district council would be mindful of the allocations it's made in terms of making sure that they are as deliverable and developable as possible. And at plan review, that may well be something that needs to be reviewed in terms of, okay, so these allocations are in neighbourhood plan areas. Are they delivering as expected? And does the plan review need to take account of that? And how does it react to that?
Yeah. So if this whole thing was sort of rewritten just to have the right-hand column, and I'll come on to in a second as to whether the figures in the right-hand column are appropriate, but you know, the figures for each individual settlement. If it was just that column, and it's just as SB04 says, is neighbourhood plan areas need to make sure that through allocations in this plan, windfall approvals and any allocations in neighbourhood plans, that minimum figure is provided for. That's probably all that needs to be said, isn't it? It doesn't need to go on about this complicated thing about deleting, you know, finding replacements for windfalls, which seems a complicated thing and is arguably inequitable, because you're requiring the neighbourhood plan areas to identify extra sites that you aren't replying non-neighbourhood plan areas. You know, if I'm in a non-neighbourhood plan area and I've got some outstanding permissions and they expire, you're not yourself saying, right, we're going to allocate some more sites at this stage, but you're requiring neighbourhood plans to do it, if you see what I mean. Does that make sense? That seems a bit inequitable to me. Whereas if you just have, this is the total figure, it's for you, the neighbourhood plan, to ensure that between allocations in this plan, outstanding permissions, and any allocations that you put in your neighbourhood plan, that figure is met, and that will presumably be tested at a neighbourhood plan. It can only be tested at a neighbourhood plan examination, can't it? Where, you know, if I'm just making the figure up, but if it comes in for Chiltern 161 and there's well, that's probably not a very good example, but you know, they haven't got enough, then that neighbourhood plan isn't going to be sound, is it? Yeah, okay. Or even legally compliant, because it won't be in general conformity with this plan. Okay, so would that be a way forward on that, to make that much clearer and do away with that sort of complicated requirement?
I think that would seem to make sense. I mean, the outstanding plan permissions column was originally added to try and add transparency, because I think some of the consultation responses, that we had back couldn't understand how the figure had been constructed. So it was an effort to be transparent in terms of the number, but I appreciate the complication of it as well. Yeah,
and then that, I think, addresses my point. I'm getting confused with my own question numbers here. I think B3 is flexibility not reflected in the 20%. That deals with that, because what I also thought seemingly unfair on the neighbourhood plans here was, and you know, we'll discuss separately whether or not the 20% buffer figure is an appropriate figure, but on the basis, assuming that it is, it seems that figure, these total homes required figures, in effect, all have 20% buffer within them, don't they? They all have that. So to make these, and that's to reflect the fact, you know, for example, Oldham, 13 homes required in total. There'll be 12 allocated in this plan. There's one permission that they've got. If that permission falls away, it's way less than 20%. It seems a bit unfair. Well, we're actually, with the approach we're going down here, but it seems a bit unfair to require them to make up that 20% when other people in the district aren't being required to make up the 20%. If other non-neighbourhood plans aren't being required to make it up, so I think that would deal with that point too. So then I think that deals with all my points on 4.8, if that's what that can go to. But that comes back, well, I suppose that brings us to 2 points, which comes back to the settlement hierarchy and the overall spatial distribution of development, that I'm thinking, okay, this is prior to our discussion, this morning. I'm thinking, okay, well, you've allocated these sites on you're saying top-down and bottom-up approach, but on the evidence before this morning, the written evidence, it's a bottom-up of these are the sites we've selected because we think these perform the best. But if one of those falls away for whatever reason, you're saying that they've got to, well, but let's take Bentley as an example. If Bentley has got its outstanding permissions of 32, let's assume that they've already actually all been implemented, so they exist. So they've all been sorted, so it's got an outstanding amount of 20 to find. If that site allocated in the plan were to get permission, today, it was to fall away. Suddenly, it wasn't deliverable or whatever. You're saying to the authority, you're saying to the neighbour plan area, you've got to find a site for another 20 in your neighbourhood plan area, aren't you? That's what you're saying, even under our new way of doing things. If it was suddenly found immediately that wasn't, well, if it was found at the point of the, if it was found at the point of the examination of the neighbourhood plan that this allocation was no longer deliverable, they would probably have to, they would have to identify another 20. But
no, not in the Bentley instance, because the Bentley instance is an allocation of this plan.
Well, it's probably a complicated, that's a debate, isn't it? If you get to that neighbourhood plan examination and there's a site allocated in this plan, but it is well known that this, you, the council, know that plan is no longer deliverable, possibly because something else has been built on the site or something, then it's a bit of a debate, isn't it, as to whether...
Well, that's where Mr. Deacon, I think, had said that would be a matter for this plan to address if it turned out that one of its allocations turned out not to be deliverable, developable. Then it's a matter for this plan to address the implications of that. Then the neighbourhood plan obviously would be looking, and Bentley for this instance probably isn't a good example for your concern.
It's the other way round, isn't it? It's my concern is more over the 32 at Bentley. If the 32 at Bentley didn't come forward, if the 32 haven't been, those permissions have expired, aren't going to be implemented, I need to know that total of 52 in Bentley is somehow a justified amount. But I will know that, I hope, because you are going to explain for each settlement why that total figure is right, aren't you? Is that? Yes. So I will know. You're going to justify why it's that figure, why it's not higher, why it's not lower. So I will have the evidence that assuming I agree, this is all assuming I agree with it, but there will be evidence to explain why you say that 52 is an appropriate figure for that village, why it's not higher, why it's not lower. That's right, isn't it?
Well, yes, although part of the explanation for the quantum of allocations at any particular village may be the extent of extant permissions at that particular village.
You see, and these outstanding permissions are either, this is where the relevance of whether they're still extant permissions or not still is relevant. If they're built, well, end of story. If they've been built, that's it, they're there. If they haven't been built, we know they've all expired, probably. But well, the majority of them will have expired. The majority of them have probably expired. Well,
no, I have to say one should be cautious about that. But both the reason I already mentioned, but also it's certainly not at all unusual for a developer with the benefit of a planning permission as at that base date of 2018, if for whatever reason they were coming up against their time limit for implementation, for them to have submitted a further application under section 73. Seeking,
and there's also they can dig a hole and
exactly. So it is. I mean, clearly the plan has to proceed on the basis of applying the deliverable and developable tests, because they're in the MPPF, to its forward supply, and it has to have made some judgments about, in a sense, those which it has no control over. That's to say, those which have already got a planning permission.
I think then, in effect, what you have to do is say, well, explaining why that total figure is correct. Yes, it has been influenced by so taking Bentley as our ongoing example, there were outstanding planning permissions for 32. You were aware of that when you were putting together the plan, and you allocated another 20 there. So you presumably thought that 52 overall was a suitable amount for that settlement. You presumably thought that, didn't you? Because if you'd thought, well, there's 32 there already, and we really think that's probably as much as that settlement can really accommodate, you wouldn't have allocated any more there, would you? I'm presuming.
So certainly on my audio, that slightly broke up between the start of the question and then the end of the question.
I didn't get it either, no.
Oh, right, okay, I'll repeat.
Apologies, I didn't quite hear it properly.
I asked what seemed to be almost a rhetorical obvious answer question, and you all looked at me blankly, and I'm thinking, oh, no. So when you looked at all this, you looked at Bentley. There were 32 permissions there already, and you've allocated another 20. You presumably did that thinking that Bentley as a settlement was suitable for 52 altogether. If you'd thought that, well, there's 32 there already, and actually that's probably as much as this settlement can really sensibly accommodate, you wouldn't have allocated another 20 anyway, would you? It would have been a settlement that didn't get any more. So to that extent, when you go through and say Bentley has got 52 because it hasn't got more because, and it hasn't got less because, the fact that we're outstanding permissions is probably included in that answer, isn't it? You took account of the sense, the appropriateness of those outstanding permissions in allocating the amount you allocated, I'm presuming.
Yes, we were mindful of the amount of outstanding planning permissions at the time of making the allocation as well.
So if none of those 32 permissions were delivered, they're all expired, you, in your judgment, are still content that 52 overall for Bentley is an appropriate figure, and you will be able to justify why it's an appropriate figure, why it's not higher, and why it's not lower. Yeah. Yes.
Yeah, I think also, sir, we would certainly need to be clear as to whether the exercise that you're asking us to do, we think that what you're obviously trying to understand is the decision-making process which led to the plan as submitted. And so obviously that's a slightly historic exercise in terms of the information that was known to the council effectively last autumn in the run-up to the Regulation 19 plan, and then obviously they were able to take into account the consultation prior to the formal submission. But obviously that information is different to what's known today, particularly in relation to any planning permissions where either new planning permissions might have been granted since then, or planning permissions which were then in existence are now known to have lapsed. And as I understand it, what you're interested in is that historic exercise, because you're wanting to understand the justifications the council had at the time for the decisions it made at the time, rather than would you make those same decisions today in the light of whatever might have changed on the ground since then? Have we got that right?
Yes, I suppose so, although I'm slightly worried by the second sort of scenario, because I think, are you saying that there are going to be significant things that have happened since you put together the plan that you would say, well, had we known this now, we wouldn't have done the plan this way? Is there anything, I mean, is there anything significant on that front?
No, I wasn't saying that there was. So that wasn't the reason for me referring to that. It was more, as it were, just a kind of a chronological point of, if we're going to undertake this exercise, we need to be absolutely clear what it is that we will be taking into account, because there will be, inevitably, just because the planning process is always changing, there will be changes. But as I say, what we're interested in helping you with, as we understand it, is providing you with an explanation of the decisions which informed the plan as submitted. We're not, as it were, trying to look at it as of today, not to say that there are differences that would be material, but just so that we can focus on the right issue.
I think what would be helpful is for each settlement, and it has to be the total figure, so it's not just the allocations, it's the total figure, isn't it, for that settlement. I'm going to go to the table 2. So pick another village, Babercore Village, Acton. So Acton will be made up of probably some outstanding permissions and allocations, won't it? Yeah. So
Yes.
And that'll have a total figure that you'll be able to put a total figure to. Yeah. So why is that total figure appropriate? That's what I would say. Yeah. Now, the question is, what date does that total figure depend on? Because well, what you've got basically, according to table SPO4 table, is you've got outstanding permissions from before 4th 18, some of which will have expired, but the majority of which will be being implemented at the moment. Yeah, and that other table that you sent through was very helpful in that regard. You'll have the new homes, which are the allocations in the plan, and you'll have some windfalls that you've granted permission for, won't you? Yeah, so I mean, I'm not going to get too excited about the windfalls because it's only 5%, but basically the windfalls sort of fall outside, this is the point that's just occurred to me, fall outside the spatial distribution, don't they? If you know what I mean. They're not, and that comes back to our discussion on the right at the beginning, which is they could be anywhere really, couldn't they? The windfalls could be anywhere. Okay, that's fine.
It could be in any category.
Yeah. That's fine. I was just suddenly occurred to me. So if you could do for each settlement the total number of allocations and existing permissions, right? And the reason why that's an appropriate figure, that probably may take it forward to reflect some windfalls that have been allocated since you made the original decision on the plan in some circumstances, won't it? But it won't be, it presumably isn't enormous numbers, is it? I'm presuming you haven't had enormous numbers of windfalls since you
There has been a significant amount of development management activity, not necessarily in the windfall categories, but across allocation sites. Yes.
Oh, in allocations, they're fine.
Yeah.
They're allocations, but I'm meaning in terms of there won't have been permissions for a large number of windfalls, particularly in one settlement or anything, presumably, will there?
I'm not aware of any particular. I mean, settlements will
And
have.
if there are, given that I'm assessing the plan now, if suddenly, and I'm not saying it's the case, if suddenly, I'm making this up just for an example, but if suddenly Elmset, meant to have a total of 49 homes, has had a windfall, granted for 120 houses or whatever, I'm going to be questioning whether your allocation of 41 is still justified, aren't I? So I need to know that, so it is relevant to now and to when the plan is adopted, as opposed to necessarily when you made the decision. Most of it is going to be your decision making at the time, reporting, but you are going to have to check that it is still relevant, aren't you? It's still valid, because the plan isn't adopted yet. You're still going to have to be happy with that judgment given the current circumstances, aren't you? Does that make sense?
Well, so if we provide, and probably there's a presentation of it's a matter that we can reflect on, but if we provide, as it were, the basic explanation of the why this amount, why not more, why not less, looking at the position as at the plan as submitted, but we also add a column, let's say, which identifies has there been any particular degree of change in, as you say, planning permissions granted subsequently, so that information is presented to you. Obviously, you can then look at that, and if in relation to settlement X or settlement Y, you take the view that actually the degree of difference poses a question in your mind as to is it still appropriate or not, then obviously we can then look at that one further to see, because there may well be particular factors or particular issues which explain that, or whatever. But if we present you with the information, then you'll be able to see how that pattern works through. And I say it may well be, as Mr. Deacon has said, there hasn't been many changes in the windfall categories, but there have been more changes in the prospective allocations categories. But if we provide the information, then you're in a position to, as it were, come to some kind of a view as to whether that gives rise to further questions or doesn't.
Yeah, I'm happy with that. Just rather than it being at the date of submission of the plan, can I suggest it's the 1st of the 4th, 21? Because all your monitoring work, when we get into 5-year supply and all that, that's presumably all going to be based on the 1st of the 4th, 21, isn't it?
It is, yes.
And it's conveniently 3 years after the 1st of the 4th, 18. So it's just a convenient date. We've got this one date, and I'm forgetting when your plan was submitted, but it wasn't a million miles off the 1st of the 4th, 21, was it?
No.
So that probably makes sense to be that. Then it's clear it's that date, isn't it? So if you could make it that date, the permissions that existed on that date, and the allocations, if they haven't already got permission, what is the total figure for each settlement? Why is that justified? Yeah, and just so I'm clear, the neighbour, I don't know, this is a further complication, I don't know how you deal with this, but the settlements listed in table 2, are they comparable with the neighbourhood plan areas, or is there further complication there? There is further complication, isn't there?
There is further complications. So there will be, because that's by settlement and not by parish, generally speaking, the neighbourhood plans are constructed on parish boundaries in terms of their designations, generally speaking. And as a consequence of that, there may be multiple settlements that exist within one parish. And so that the number that derives from them is the number within that parish. For the purposes of table 4, it's the numbers within the parish, if you like, assuming the neighbourhood plan is based on a parish. But the construct of the settlement hierarchy is yes.
But that's okay, isn't it? Because if you do this work for the table 2, if I'm looking at, I don't know, Great Walding, Hadley, for example, I have no idea, but if I'm looking at Hadley, and Hadley Parish is made up of several settlements within Parish 2, as long as I've got the justification for each of those individual settlements, then the total figure will be justified as well, won't it? So, if that makes sense.
Yeah,
Yes.
but it's also fair to say that not all parishes within the 2 districts have neighbourhood plan areas, because not all of them have taken up the opportunity to either bring forward a neighbourhood plan or even to prepare a neighbourhood planning group and so on. So table 4 doesn't cover every parish in the district.
No, but table 2 does, doesn't it?
By implication, yes, because all of the settlements are in a parish, or several of them are in a parish. There aren't unparished areas in the 2 districts.
Yeah, right. Okay, so it's table 2 that needs to have the work done against the settlements, and in fact, it's probably easier just to stick with table 2 and then to say, because I mentioned before that I'd like you to do by, a sort of overall picture for each settlement level within that area, but that's in table 2 as well, isn't it? So it's like, Baber Ipswich Fringe has got this amount because, blah, blah, blah. It's not higher because, it's not lower because, and then individual settlements within there have got these figures because type of thing, and that then covers the whole thing. And that, as far as I understand it, if you provide me that is the exercise that you undertook in preparing the plan, the work that you undertook, but haven't numerous meetings and discussions and what have you, but haven't actually written down at any point yet to us. And if you can write that down, that would be extremely helpful. And that would deal then with the neighbourhood plan issue. Yeah, I think. Okay, I think that's gone through all the questions. Just before we sort of summarise, is there anything from you, or should we now go anything further from you, or should we just go through what it is I'm asking you to do, just so you're clear?
There's not from me, thank you.
Right. Okay, so basically, just so you're clear, and then we can talk about how long this will take. And I'm thinking it might be wise if we do break and have lunch, and you come back this afternoon, it gives you time to have a chat about it. So I'm asking you to look at SPO 3 to look at, it's looking at SPO 3, SPO 4 and LPO 1 together to make clear, in effect, what the policy is requiring in relation to what is windfall development, because that's what it's going to apply to. And if it was, I'm not absolutely requiring this, I may do down the line, but I give you the option to come forward with what you want at the moment. But to my mind, my initial thinking is if the policy was basically part 2 and part 3, with the last sentence of part 3 altered as we discussed earlier, particularly to take out reference to isolated locations development, then I think that would probably do the job. But that's just my thought at the moment. And if you want to come back with anything else and you've got concerns about that and you think there's problems with that, then feel free to come back. But you understand my point about it needs to be clear that this is applying to only to windfall development, and it needs to be clear that it's, in that example that we talked about of a windfall for 50 dwellings, that in effect the hierarchy would not be being applied within a settlement boundary, because that wouldn't be being applied, would it? So I think it doesn't need to make that clear as such, but it needs to not imply that it would do, which it would take account of that, which is what the policy does at the moment. Okay. So the same then goes for policy SPO 4. You're going to have a look at that. you've agreed that, I think you've agreed that the specific figures are unhelpful in terms of they're always out of date, and for development management purposes, they're not going to be applied anyway. But I take Mr. Bedford's point that there is probably a need for a policy that sets out in broad terms what the distribution is, but that can set that out whilst making it clear. And then you're looking also probably at changing the table to just have the total homes required column, yeah, and altering the wording in SPO4 to make it clear that this is what the requirement is, and it needs to be made, you know, neighbourhood plans need to make sure that this figure will be met either through allocations in this plan, you know, outstanding permissions or allocations in the neighbourhood plan. And I think that wording saying that would actually be very helpful, because that then is explicit to the neighbourhood plans what they have to do, isn't it? I think that was it in relation to the actual policies and plan. Have I forgotten anything on that? No. And then in terms of the sort of background evidence work, you're going to, in terms of the Sheila, you're going to provide the stuff that apparently does exist in terms of the more detailed assessment of the sites that are discounted. Yeah. And then you're going to come up with what we've just talked about there, which is this explanation for why on table 2 and table 3 for each district, why you know, saying what the figure is for Belstead, for Hadley, for all of these districts, what the housing figure is, why it's that figure broadly, why it's not higher, why it's not lower, and then the same sort of summary for Baber, Ipswich Fringe is higher. And just thinking about it, they're not a summary of each other, but they almost like complement each other, in that you're going to say Baber Ipswich Fringe is presumably, that's a high figure because it's close to the urban area, it's blah blah blah, it's this. And so Belstead, well, that's a high figure because it's within the Baber Ipswich Fringe, and that you see what I mean. So they're probably complementary rather than a summary. But yeah, okay, I think that's it. Now that, if you can get all that, that would be very helpful. And as I just want to re-emphasize that at the full Matter 4 session, we'll obviously, which is also going to discuss SA, you know, it's entirely without prejudice to what others might say and what views I might take on what other people have said. But I think this work would be extremely useful for me for trying to assess whether or not the spatial strategy is based on an appropriate strategy, and whether or not the site selection process has been robust in its conclusions. I understand the process you've gone through, but I need to understand that final decision making as to which sites went in and which were didn't, and why. I think the key point is that all of that work would be very useful to have for the Matter 4 session, right? Because I think otherwise the Matter 4 session is going to be people who are probably listening to this at the moment or going to listen to it over the next few days if they've got better things to do at the moment. I can't imagine how they could possibly have anything better to do than watch this, but anyway. That they're going to be saying, well, what's the point of discussing all this if you're going away, discussing stuff again in September, in the autumn, if we haven't got this work. And I think probably, although if you come up with changes to the policies, they would obviously then be subject to formal main modification, full consultation after those hearings. So I'm not, you know, those hearings wouldn't be the final say on it, but equally it would be useful for us to have your ideas on what the wording should be at those hearings, and probably I would say 2 weeks, at least 2 weeks before those hearings, so people have got the chance to have a look at it on, in effect, an informal basis. Now, I'm not going to be asking for written statements on it from people. People can look at it and we can talk about it at the hearings. But I think it needs to be 2 weeks, at least 2 weeks before, so give people time. Mr. Bedford, you about to say something?
Well, yes, but I absolutely take your point in terms of, obviously, if there are changes or suggested changes to the wording of policies, obviously they would, in due course, before they could go into the plan, have to have formally gone through you having come to a conclusion that they're needed in order to make the plan sound, and therefore a consultation process. So I'm not troubled at all about that, as it were, process and how it would work. But bearing in mind the further, what you might call evidence-based explanation work that you've also asked for, in terms of the scale, effectively, of growth to individual settlements, why that amount, why not more, why not less, that's evidence-based explanation work, which what I'm simply concerned about is the logistics of the Matter 4 hearing session. If it were the case that we provided that information into the examination, let's say 2 weeks before that hearing session, I am quite sure, without in any sense of being in any way critical of anybody, but I am quite sure that the explanations that we provide won't be met with universal, as it were, endorsement and agreement by all participants. And there will be people who, for various reasons, will want to say something about those matters. And that's entirely legitimate because they're being presented with new information. But in terms of the process of actually then trying to proceed, as it were, in an orderly fashion with your hearing sessions, if there has been nothing from those participants ahead of the hearing sessions, so the first time they're able to make their points are at the hearing sessions themselves, I can see that there is a risk that the sessions will become very difficult in terms of unwieldiness, and also in terms of the council and you being able to focus on what are the, as it were, the key issues, because there will be a whole range of points potentially coming forward from a whole range of people quarrelling or disagreeing with this judgment or that judgment. So I was just, as it were, floating the possibility, and obviously it's all subject to the timetable and so on, but floating the possibility that the council provides its information slightly earlier ahead of that Matter 4 session, but that you also expect people to provide at least, as it were, their summary response to those points in advance of the hearing, so that you're then in a position to form a view as to which of those issues you actually want to explore in the hearing sessions.
That's all very sensible, and that would be my ideal world, but and I'm more than happy with that. But that extends the process, probably, doesn't it? Because there's going to be a certain amount of time for you to do this work. I mean, if you can do this work this afternoon, I'm joking, but you know, if you could rattle this work off this afternoon, well, then that would all be fine. It could go out to be consulted on tomorrow, and people could be given 6 weeks to read it, 6 weeks to look at it, or 5 weeks, 4 weeks to come back with their comments. We'd get the comments back, we'd have them 4 or 5 weeks before the hearing, so that would all be wonderful. But I doubt you can get this work all done this afternoon.
Yeah.
And yeah, that is the ideal, but what is that going to do to the timetable for the examination? That's all I'm saying. That's why I was suggesting that I think we probably, I mean, it's useful to make that point, but I think it's probably useful to, rather than decide this now, have a break, you go away and talk amongst yourselves as to how long this work is likely to take now that you know that you're doing it, what you're doing, and then the implications for that, we can come back this afternoon and talk about it.
Absolutely. So can I say we did use the earlier break to give the matter some broad thought, and realistically taking into account both the stage 2 matters statements, which are due on the 13th of August in any event. So that's a separate stream of work, which obviously is already taking up time. Also, as you may not be surprised to learn, at least some team members have attempted to book some leave during the period. So what we had come up with, and this obviously then impact precisely on your point about how does it work with the timetable, what we had come up with is that we would be in a position, we expect, to respond to your request for information by Friday the 10th of September.
Right.
But obviously that then would make it challenging to do what I was talking about if the Matter 4 session was to be the one which I think may have been potentially earmarked for the 22nd of September. But obviously if one of the later dates, which I think there have been some dates in October have been at least earmarked, that it would be possible to do a round of, as it were, the council providing its information, people having an opportunity to consider that and provide something to you in writing ahead of the session. But it depends precisely on how you want to structure the remaining sessions.
I think, yeah. So basically, what you're saying is Friday the 10th, based on your discussion from before and what you've again heard now. I mean, you haven't changed anything, but now you've got a clearer idea. You're confident that you could get all that by Friday the 10th of September, are you?
So that's what I'm being told, yes.
Yeah. So if you could get that by Friday the 10th, now I agree that giving people the opportunity to see this and write comments on it is before the hearings is ideal. But in reality, I think we would need to give at least 3 weeks for people to look at it and comment it, because they've got to look at it, understand it, and then write their thing, haven't they? So that's, say, at least 3 weeks, and then it needs then at least another week for us, everybody, to read it, because there's no point in stuff coming in if I haven't had a chance to read it, if you've not had a chance to read it. So that's at least another week. So that's 4 weeks. Probably, bearing in mind that these 4 weeks are weeks of which all of us may actually be sitting on other things, so we may need a bit more. So it's it's a difficult one, isn't it? Annette has come in here now. Is there something you want to say, Annette? I think it would be useful to comment. Or did you just come in to?
I take on board Michael Bedford's points and yours, Inspector, and they're all valid. And obviously I'm mindful of the correspondence I would have from the public, parish councils, other agents, etc. And I think it's really helpful we've had that indicator date from the council of their work. As you're aware, Inspector, we've been working on a programme for the autumn with dates, and I just wonder if we could take the opportunities you suggested to have that lunch break and to consider a timeline and to come back after lunch rather than trying to do it all in public domain now. Just easier conversation to sort of look at dates in the diary.
Yeah, I think so. Maybe, well, actually, we don't actually need to finalise a date for all this today, now, here. Because the programme is, we are, for people who are watching outside, we are working actively on the programme and hope to be able to announce something fairly soon. But it's only really a date for all this is only really relevant in relation to the programme, isn't it? If you know what I mean. So we don't have to announce it here and now. So, but shall we take a break then and come back? I'd suggest 2:30, because that gives a couple of hours to have this discussion. It presumably won't take very long when we get back, and that enables us to have a bit of a you to have discussion and thought, and also me and my colleague Inspector to have a bit of discussion and thought. Does that make sense?
Yeah.
Yeah. Okay. Well, it's 12:25. 12 now, so let's adjourn now and we'll return at 2:30. See where we are, but as I say, we're not necessarily looking to absolutely bottom out a precise date here and now. We can agree that outside the hearing and make sure it's all clear on the website. Okay, thanks very much, and see you this afternoon. back. I'm hopeful that this will be a fairly short session, but where we left it this morning is we'd outlined and agreed the further work that's going to take place. Your council, you'd indicated a date in September, which I think you felt you were able to produce this work by. In the meantime, I know that Annette, the programme officer, has shared with you our sort of initial draft of the revised programme for the autumn, from the postponement of earlier this month. So you've had a chance to have a look at that. In the light of that, do you think that that this date is still achievable on what you further thought, and that it could be fitted in to this programme, giving time for adequate consultation and comment? Who from the council wants to come back?
Yep. So yes, we have seen what is clearly a draft of a programme, but on the basis of the indications there, together with obviously Mr. Deakin and his team, and the work streams, we are content that that is achievable. It allows for us to produce matters in advance of the resumed hearings and to allow parties an opportunity to comment on that in writing in advance of the resumed hearings, which I think from a logistical point of view is going to make the process more manageable, and we're content with that. And obviously the fine tuning of the timetable will be a matter the programme officer can advise us of in due course.
Right, okay, that's absolutely fine then. I mean, for those watching, well, for you, the council, and for those watching, we're hopeful of coming out with the programme well, at some point next week. So that'll then be circulated, and that'll set out all the relevant dates there. But if you're confident that you can meet that, then we'll go for that. Just one point in relation to the work, perhaps just worth mentioning, in terms of the sort of evidence-based work, the details on justifying the allocation, well, the number of houses in each settlement. What it would be worth, I think, you doing, if you could do an example, just say for one settlement type of thing, and let us just see that, just so that we can see whether it's the sort of thing that we think is needed. And once we've seen that for one, you can then go away and do the rest, because I think the timescales of it are that we're probably not going to have much opportunity, if any at all, to look at it between, you know, whenever it is you finally produce it and it going out for consultation. So if we see just an example of one settlement, just to make sure that it does what we think it needs to do, type of thing, and then you can then carry on with all the rest to the same. Is that okay? Does that make sense?
Okay. Yeah. Yes, that's fine. Yep.
Right. Okay. I think that is probably it. Fairly short and sweet, unless there's anything else from anybody else. No,
thanks, sir.
No, thank you.
Okay, well, thank you all for that. And just for anybody else watching, as I say, we will be having a full Matter 4 session in the autumn. We'll be going through these same points, so it's not as if any matter has been finalised in my mind or my colleague's mind. So we still have open minds, but this is some primarily at the moment evidence-based work, which hopefully will help inform those discussions. So it's just to make that point clear. So thank you all for your time today. Thank you to those who've been watching, and look forward to seeing you in the autumn. Okay.
Thank you,
Thanks
sir.
very much.
Thank you. Bye-bye.
Bye-bye.